Hi everyone, and welcome to video 4 in our series of short but hopefully informative videos to help in particular employers navigate these really challenging and uncertain times. You stuck with me again for this video, and my name's Davies. I'm a lawyer with Norris, McKinnon. In this video we wanted to delve into what has become a really tricky topic, and that's the impact of changes that the government has made to residential tenancies on service tenancies. What is a service tenancy? Well, in a nutshell, a service tenancy is accommodation provided by an employer to an employee as a condition or benefit of employment. Service tenancies could be shared, with more than one employee sharing the accommodation together and just having exclusive use of one bedroom, or they could be standalone, with the worker enjoying exclusive use and possession over the entire tenancy for them and their family. On the 25th of March, the government passed the COVID-19 Response Urgent Management Measures Amendment Act. Now that made a number of changes to different pieces of legislation, including the Residential Tenancies Act 1986. These changes also affects service tenancies, and that's irrespective of whether or not the tenancy is fixed term, i.e. for a defined period of time, or periodic, from month to month. Key changes include a 6-month rent freeze, as well as a 3-month moratorium on ending tenancies, evicting tenants. Significantly, the 3-month moratorium on ending tenancies could be extended by the government for a further 3 months if required. That first 3-month period ends in late June, but could be extended until late September. During any period in which these changes are in force, service tenancies cannot be ended, except in certain circumstances or by agreement. In particular, any notice that a landlord may have issued on or after the 26th of March, which purports to end a tenancy or increase the rent payable for the tenancy, is of no effect. And any notice by a tenant issued on or after the 26th of March, which purports to end a tenancy, can be changed by the tenant so that it is of no effect. In other words, a tenant that's previously agreed to leave a service tenancy could change their mind. Notwithstanding these changes, it's important to remember that tenants are still obligated to make reasonable efforts to pay rent and remain liable to the landlord for any rent arrears. So, how can tenancies be ended during the time these changes are in effect? Well, by agreement, in cases where both the landlord-employer and the tenant-employee agree to end the tenancy, and where the tenant-employee leaves the tenancy voluntarily, or by order of the tenancy tribunal. Now that's going to apply in cases where the tenant substantially damages or threatens to substantially damage the tenancy, assaults or threatens to assault the landlord, the landlord's family, or any of the tenant's neighbours, where the tenant abandons the property, where the tenant engages in antisocial behaviour, which is behaviour that harasses others, or any intentional act that could reasonably cause significant alarm, distress, or nuisance, and in cases where the tenant is 60 days or more behind in rent. Although we note the tenancy tribunal in those cases will still take account of whether the tenant is making reasonable efforts to pay rent, which could be influenced by the fact the tenant is either unemployed or is receiving less income than previously. All of the circumstances I've just listed require an order of the tenancy tribunal. Now that means a landlord needs to make an application to the tribunal to end the tenancy. The Tenancy Tribunal is hearing many of these applications on the papers. That means without a physical in-person hearing. But landlords will need to factor this additional step and the time in particular that it will likely require into their decision making. These changes will obviously impact employers who require service tenancies for their essential employees because of a change in season, i.e. the beginning of a new farming season, or because of other factors like the conclusion of a disciplinary process that results in an employee's dismissal, or as a result of a change process that results in an employee's position or role being disestablished. While these processes can still take place, so an employee's employment can still be ended where the process was fair and the justification underpinning it was fair and reasonable, they will no longer serve to automatically end a service tenancy as they once did. One thing to bear in mind, particularly if you're a landlord, is that the penalties for breaching these changes can be really significant, and they can include exemplary damages of up to $6,500. So what do we recommend given these changes? Well, firstly, communication is essential. If a landlord and tenant can agree on ending a tenancy, the process is largely unchanged. But if agreement cannot be reached, the tenant may be able to stay in the tenancy, irrespective of the kind of tenancy, i.e. fixed term or periodic. In that case, they are still liable to make reasonable efforts to pay rent, and they're liable for any rent arrears they owe. Employers should take these changes into account before commencing a disciplinary or change process. The changes themselves to the service tenancy I'm talking about won't necessarily and shouldn't affect the outcome of either process, but there will be practical implications if a tenant's employment is ended that an employer obviously is going to need to be aware of. Significantly though, employers should avoid delaying commencing these processes just because of the moratorium, as there's still an obligation to remain responsive and communicative with employees. For example, raising any concerns that you have promptly and without delay. Look, these are really challenging and unprecedented times, and the impact on tenancies could be significant. If you're stuck, give Federated Farmers a call and chat to someone like me, and we'll do what we can to guide you through the process. Otherwise, keep your eyes open for any changes that may be made by the government. And the next critical step, particularly insofar as the moratorium on ending tenancies is concerned, is going to be late June. If that moratorium is extended until late September, it may factor into your decision making as an employer. But most importantly, keep calm, carry on, and wash your hands. See you next week.